So I'm Jessica. I'm a family lawyer based in a firm of solicitors in East Yorkshire, and I predominantly represent parents within public law proceedings. I find that parents with learning difficulties or disabilities can struggle to understand and follow the court proceedings and process. They tend to struggle to read court papers and can be easily overwhelmed with the amount of appointments, court hearings, and contact. And when presented with new documents, they can find that difficult as well. I try to manage a parent's expectations before going into court and talk them through in a very simple way what is likely to be discussed or happen in a hearing. I have in some cases shown them around the courtroom before a hearing is started to prepare a parent. So if I find that a parent is not following a hearing or appears overwhelmed, then I do ask for a break from the judge so that I can step out for a few moments with a parent and double check that they're okay and whether they've got any queries that they want to put to me, and then hope that it's that they found it able to then rejoin the hearing. I use simple layman's terms wherever possible with a parent. However, the use of an advocate or an intermediary can greatly assist with this as well and ensure that a parent can participate within the proceedings. There is some legal aid available for parents pre-proceedings, particularly if a local authority has commenced the public law outline process. This enables parents to seek legal advice and assistance and are able to ask questions. However, the funding is limited, and any additional support, such as an advocate, is dependent upon the local authority funding such support. And so again, that can be limited as well. I haven't experienced the use of intermediaries during pre-proceedings in our area, but have experienced the use of intermediaries during public law proceedings. Their availability tends to be good as long as they're booked in advance and an assessment has taken place in good time. There has certainly been an increase in the use of intermediaries. However, there's been recent case law which may now affect the use of intermediaries within family proceedings and the availability of that resource being able to be accessed, and may now lead to a reduction in that use, which is unfortunate. There is a real lack of local advocate services within our area, and often there's a real delay in an advocate being appointed to a case, if at all. The funding for an intermediary within proceedings is very limited and tends to just be available by the court fund for assistance within hearings only, and the legal aid agency do not tend to fund the use of intermediaries for conferences away from hearings, which can make it difficult when needing to hold legal conferences and meetings with them away from the court environment. I would say it's important to try to recognise early on if there's any cognitive difficulties or capacity issues with a parent and seek a cognitive assessment as early as possible. This can be crucial as it assists and guides all professionals, including yourself as their legal representative, upon how to support a parent and help them participate within proceedings. It leads to necessary support and avoids delay in the triggering of this support as well, and it being accessed for the parent. It is really about trying to build a network and a package of support around a parent, which tends to lead to a more positive outcome for a parent. For instance, a parent may enter supported housing, which enables access to day-to-day support for them. But alongside that access to local resources and support is also important, such as from children's centres or family. It's about identifying what support may be available to an individual parent and identifying when a local care assessment, for instance, is needed for a parent, which then leads and triggers more support for a parent.